Hey, everybody. I am a little off schedule this week. I know usually I go live every Thursday at 12 p.m. Eastern time, but today my daughter is doing swim lessons, so we are just a little off kilter this week, but I appreciate you guys bearing with me being a little late. And let's dive into this week's Facebook Live and podcast episode. So I have today for you the simplest legal protection that you can imagine. It is going to blow your mind, but you would be surprised at how many business owners I see who are not doing this in their business. So today we are going to be talking about actually getting your contract signed. And I know you think, this is going to be like a 1 minute, 1 minute live or 1 minute podcast episode. But there are some best practices and some details and some tips that I have here. And I do get questions about this from time to time. So I'm going to go dive in and give you my best tips on actually getting your contract signed. And if you don't know me already, I am lawyer Autumn Witt Boyd. I live in Chattanooga, Tennessee. I am licensed to practice law here in Tennessee. Please take everything in this episode just as information. It is not intended to be legal advice. If you have a specific question about your business, please check with a lawyer, whether that's me or someone else, to make sure that you are getting the best advice for your business. All right. Now, I'll mention we do have a resource that goes with this episode. If you go to our website, awbfirm.com/podcast, the number 146, that's our episode number, podcast 146. You can find the show notes for this episode, and you'll also be able to download our guide for how to write your own contract with 5 key terms. So since we're talking about getting your contract signed, if you don't have contracts and you need help, that is a great resource to help get you started. All right. So I think if you've listened to me before, you know that I think contracts are the number one legal protection for your business. I know they're not as sexy or fun as some of the other things that we work on with clients, like trademarks, copyrights, setting up an LLC, but contracts are really the foundational legal protection for your business, because most of us are starting businesses doing one-on-one services, or even if we're selling products, maybe we're doing some wholesale accounts, any kind of business that you have, contracts are going to come into play. So we want to make sure not only do we have contracts, but are we actually getting them signed? So I will start by telling you, this is not a legal requirement. So there is no, except for a couple exceptions that I'm going to list in a minute, there is generally no rule that a contract is only valid if it's actually signed by both parties. Even in some situations, you can have a verbal agreement. You can have oral contracts. That's totally acceptable, except for these exceptions that I'll go over in a minute. But the problem here is that if you do have a dispute, if you have a disagreement with the other person on the other side of the contract, if it's not signed by both of you, it's going to be kind of up in the air. Was this the final version of the contract? Did we both really agree to all of the things in the contract? The signature is just evidence. I always tell my clients, let's think about if we had to go in front of Judge Judy and you tell her that you have a contract, she's going to say, well, where's the contract? And how do I know you both agreed to it? Where's the signatures? So signatures on a contract for most cases are really just good evidence that you both agreed to it. Sometimes with my clients, we will go through 5 or 10 rounds of negotiating terms of a contract. And so, the prior drafts won't have signatures. That's how we know they're not the final draft. That final draft is going to have the signatures of both parties. That's how we know that's, it's got everything that we agreed to. So a signed contract is your best evidence that this was our agreement. Now, here are a couple of exceptions where it is a legal requirement that your contract must be in writing, signed by both parties. These are under Tennessee law. This varies a little bit state by state, so your state may have a couple different rules, but this just will give you an idea. Contracts, if you're selling something for more than $500 in Tennessee, that has to be in writing. The sale of land or a lease that lasts longer than 1 year has to be in writing. Any contract that by its terms will take more than 1 year to complete. So if you have, a 2-year service agreement or, I reviewed a contract last week for someone who's having Wi-Fi at their house installed, really, really high speed Wi-Fi, and they had to do a 5-year contract. So, any contract that will last longer than a year has to be in writing. And any contract to lend money or extend credit has to be in writing. Again, these are all under Tennessee law. Your state may have some similar rules. But with most of my clients, we are working in online business. We are providing creative services. We are doing coaching. For most of my clients, these rules, which are called the statute of frauds in most states, just don't apply. So what we're talking about, not necessarily a legal requirement, but best practices. So let's go through a couple of examples. So if you are selling something online, this could be, for my life coaches listening, maybe you're selling a coaching package, but you have a checkout page on your website where people can just purchase there. For my online course creators, you're selling access to your courses. Or if you sell digital products, like we sell contract templates here at the AWB firm, you're selling online. It's all e-commerce, but it's not a physical good. You are going to want to have some sort of agreement with your customers, because these things that we're talking about are basically all either a service or they're intellectual property based. So we want to have some terms around how we're going to work together, or what permission do you have as you're going through the course to use the materials? Can you share them with a friend? If you misbehave in the Facebook group for the course, can you get kicked out? There's lots of things. I'm not going to go into what your contract should say. But even if you're selling something online, you probably are going to still want to have a contract as part of that. So how do you get the student or the purchaser, your coachee, your client, to agree? Couple options here. So my favorite is the checkbox on the checkout page. And this is going to depend a little bit on what software you're using, what checkout, service provider you have, how your website is set up. But most of them will allow you to add a checkbox at checkout where you want to start with it unchecked and where you require your customers to be able to purchase, they have to agree. So, and you might have some language there that says, by checking this box, you agree to the terms. Something like that. With all of these, I want you thinking, you want the purchaser to take some affirmative action. They have to do something to show that, yes, they do agree to these terms. Because again, if you go in front of Judge Judy and she asks, well, how do you know that he agreed to this contract? You can say, well, I have a checkbox on my checkout page, and you could show her a screenshot. In order to purchase, they are required to, check that box. The second option, if that checkbox is not available, could be just some language on your checkout page. You want it to be pretty easy to see, so you don't want it to be in teeny tiny type. You want it to be pretty visible, maybe even in a different color or with different font, maybe a box around it that makes clear, by purchasing this product, you agree to these terms. And for either the checkbox or just the language that says, by clicking purchase, you agree, you want to make sure that the customer has the option to view and read and digest the terms, the contract, before they purchase. So this is not something that we want that they can only see after they've purchased. We want to give them the option to look at it, to make sure that they do agree. Because again, if you go in front of Judge Judy and she wants to see your page, but there was no way for them to actually read what they're agreeing to, you're not really agreeing to a contract if you didn't have a chance to read it, to review it, and make sure that it fits what you are comfortable with. Ideally, if possible, you would also send them a copy of the agreement after they purchase. So maybe in the confirmation email, or if it's an online course with lots of different resources, you could put it there if everybody is signing the same terms. So it's going to be the same for everybody. But somehow you want them to have a copy in their records, or put it in a place on your website where they can refer back to it easily. Now, if you are updating your terms frequently, you want to make sure that you have a date on those terms so that it's easy to see, oh, well, this person purchased in 2017, so I've got to go back in my records and find, what was the version of those terms if you have a question later. So if you're selling something online, having a box that people check at checkout is just fine. But again, you want to think about making them take an affirmative action and making it very easy for them to review those terms before they purchase. So I get a question about this. I do have some clients, especially that sell maybe higher end offers, that they do a phone consult or a phone, sales call with their potential customers, and then they sell over the phone. So they want to get that agreement, they want to get that contract signed before the person hangs up the phone call. Now, I think it's not a bad idea to go over the contract over the phone. So if you're in a sales call, I don't have any problem with you, either emailing it to the person, or if you're doing a Zoom call or somewhere that you can share your screen, pulling it up, walking through it term by term so that it's very clear, everyone understands what they're agreeing to, and if there are any questions, you can address them right then. I think that's great. But where I do see that this can become a high pressure tactic, it can be somewhat coercive, is if you are not taking that time to go over the contract with them. You just send it to them and you say, you have to agree right now, or this deal is off. You don't give them really any time to read or process. I'm a lawyer. I read contracts all day long. I will tell you, if I were on, a high pressure sales call and required to read a contract right then, especially a long one, and try and decide is this for me or not, and maybe even there might be a couple things I would want to see if I could negotiate, that's not going to sit well with me. I need a little brain space. I need some time to think about it and process, and maybe even print a copy and take my red pen and circle things that I have questions about. So again, there's lots of different business practices out there. I am a fan of, a gentler, softer approach. And I think when it comes to, if you did have a disagreement down the road, if someone has second thoughts, maybe because you pressured them to sign up right then, and then they read the contract later or they think about it, I think it's going to turn into a customer service problem for you later. These are the kinds of people who, if they're having second thoughts now, they're going to want to quit the program, or they're going to want a refund for your course, or they're going to want to, quit the package early if it's a coaching package. So I think it may be a short term, maybe your conversion rate goes up by doing this high pressure sales tactic. But I think in the long run, it's going to come back to bite you with a lot of customer service demands and problems, and, maybe customers who aren't really ready for what you're working on them with. So I am a big fan of giving people time to think about and make sure that they're making the best decision for them on the front end, rather than, pushing, not giving them a chance to read the contract and really understand it, ask questions. I'm not a fan of the high pressure, no time to read tactic. So if you are selling over the phone, I would still encourage you maybe to give people a day to make a decision. Give them a chance to read it when they're not on the phone with you, when they have a minute to kind of think and digest, and maybe even ask their lawyer to look at it if they have one, or ask a friend who's got experience. They may want to ask questions. Okay, and then the third scenario I want to talk about is if you're sending individual contracts. So let's say you're a graphic designer and you work one-on-one with clients, or you're doing online coaching, but it's a one-on-one type service. An online signing platform is absolutely what I would recommend you look into. I will tell you, when I first started my law firm 5 years ago, we have it's called an engagement letter. It's just a contract between the lawyer and the client. I get that signed by every client. And when I first started, I was like attaching it as a PDF, sending it by email, asking them to sign it, scan it, send it back to me. Guess how many of those I got back? It was terrible. I got very few back. I would have to harass and, cajole and try and get my clients to do it, because I really wasn't supposed to start working until I had that signed contract. Ideally you have all your ducks in a row before you start working. But a lot of times the client just wanted to get moving. And so it became this kind of roadblock in getting started with people. When I switched to an online signing platform, my signatures, I was getting those signed engagement letters back, in minutes after I sent them out. It was just so quick and so easy. It was transformational. So if you are not using an online signing platform, maybe if you're meeting with clients in person, that's one thing, if you can get them to sign it there. Again, I would ask, if you might want to give them some time to think about it. But if you are going over it with them and, giving them a chance to ask questions, that might be okay. But if you are doing online business, an online signing platform is the way to go. So you've got a couple of options here. If you are using a CRM, a customer relationship management tool like HoneyBook, 17 Hats, Dubsado, there's lots of other ones. They kind of manage your whole process from when someone contacts you through agreeing to work with you, signing the contract, paying the invoice. They have an integrated contract signing platform, so that's awesome. Those are great tools to use if you're ready for those in your business. There is a cost for those systems, so not everyone starts using them from day one. But if you're not ready for like the whole kit and caboodle system, there are inexpensive signing platforms. We use HelloSign at my law firm. There's Adobe Sign is another popular one. There's lots of others. If you Google, document signing platform, you'll find a bunch. Many of them will allow you to send 1 or 2 contracts a month for free. So that's a great option if you're not doing a ton of clients a month. That may be enough for you. And if you are paying a fee, it's usually $5, $10, $15 a month. It's not super expensive. So those are all a great option. I will tell you the great news is these electronically signed documents are totally legally binding. So they are as legal as if you were sitting in person, signing with your blue ink pen. There's actually a federal law called the E-Sign Act passed in 2000, basically saying that electronic signatures are totally valid so long as both sides agree that you can use electronic signatures. There are a couple exceptions that I will run through. They're mostly legal documents, so I don't think this is going to come up in your online business, but just FYI, if you're doing a will, a codicil, a trust, any kind of estate planning document, those cannot be electronically signed. Adoption paperwork, divorce decrees. There are certain types of commercial contracts that you can't do with e-signatures. That is not going to apply to our online businesses. Court orders and notices, official court documents. Again, these are mostly legal documents, not really business documents. Notices of termination of utility services. If you have a mortgage, notices of default, foreclosure, repossession, eviction, that could be for rental as well. If your insurance benefits are being canceled, product recalls or notices of material failures. So again, not really online business issues. And then documentation accompanying the transportation of hazardous materials. None of that can be e-signed. But like I said, for most of our online business functions, that's not going to be an issue. So an e-signature is going to work great. Now, the nice thing about all of these electronic signing platforms is that they will create what's called an audit trail for you. And if you've ever e-signed a document and you've noticed that there's an extra page on the back when you get the PDF, the fully signed document that has kind of a bunch of gobbledygook, that's what that is. That's an audit trail. So that has some information about who signed, where they were, when they signed it. It might have an ISP address, an internet address. This is all just evidence so that, again, if we have to go in front of Judge Judy, and John Doe on the other side says, I didn't sign that contract electronically, you can say, well, it was signed at this place. This is the ISP address. You can kind of do some matching. You can ask, who had access to the email that the contract was sent to? Was it only you? And then, you can now put together a pretty good circumstantial evidence case that, yes, this person did actually sign the contract. That audit trail will help you kind of do that matching. And it's just evidence that this person really did sign and really did agree to this contract. All right, I hope that was helpful. If you have questions about getting contracts signed, our Legal Roadmap Facebook group is a great place to ask questions like this. So if you're not already in that group, head on over to Facebook. You can just search for it. We do ask a couple questions just to make sure that you're a business owner or potential business owner. You don't have to be up and running yet. And then we'll let you write in after you answer those questions. And we have conversations about these kinds of topics all the time. So that is a great place. You can also drop them in our Facebook or Instagram profiles. We love to, chat with people there. And if you have another question, I might answer it on another Facebook Live next week. So this is the last in our series of kind of business mistakes. We are going to go into a series coming up that is going to be diving into different kinds of businesses and what kinds of legal protections, contracts, other things did they need. So we'll be talking about like a photography business, a wedding venue business, a graphic design business, different kinds of businesses. What do they need? And we're going to be interviewing some of those kinds of business owners to talk to them about their business, about what kind of legal issues they have seen pop up and what legal protections they have put into place. So I'm really excited about this series. It's going to be fun. And I think it's going to be really, really useful for you guys as listeners. So definitely stay tuned for that. Subscribe to the podcast if you haven't already, or if you're watching this on YouTube, you can subscribe to our YouTube channel. And I will talk to you guys soon.